This is a podcast series picking up on particular aspects of construction law and professional negligence. The first segment of the series is going to be dealing with the Building Safety Act, and we'll be giving an introduction to the main remedies that are being exploited following the 2022 Act and providing a discussion about recent cases. I'm joined here by Sian Mirchandani, KC. Sian took Silk in 2019. She has extensive experience of construction disputes, broadly defined, including claims of the nature which we will be discussing here. She also has extensive experience of professional liability disputes with and without a construction dispute angle. I'm Paul Fisher. My practice is quite similar to Sian's, with a primary focus on construction disputes, including, just like Sian, domestic and international disputes. I've worked with Sian also on a number of the types of claims that we're going to be discussing during the course of this series. The Building Safety Act is arguably one of the most significant changes to the construction disputes landscape since adjudication. And it's introduced a number of new causes of action, it's extended limitation periods, and it has also given rise to new types of claim that we'll be discussing in due course against product manufacturers who produce these products that serve as components within external wall systems. But of course, the Act extends much more broadly to building safety defects, and we're not solely concerned with cladding issues. But it's worth taking a step back and thinking a little bit about how we got here, because everyone will be aware of the Grenfell fire tragedy, the disaster of June 2017, in which over 70 individuals tragically lost their lives in a fire that was precipitated by and exacerbated by the particular external wall system and cladding that was used at Grenfell, namely an aluminium composite material. Subsequent to Grenfell, we saw an investigation by the government which identified over 400 buildings over 18 metres in height that included this ACM material. And then there were further reviews that took place after that, weren't there, Sian?
Indeed. We shortly after the fire had the start of the Hackett review, the independent review considering the building regulations and fire safety. And the final report of that was in May 2018. And then after that, you and I both experienced this, what has been described as the tidal wave of claims washing into the technology and construction court, arising out of those properties where there were these kind of external wall systems, which included aluminium composite materials, but also other aspects, not purely relating to the cladding. And we saw a number of other fire safety issues cropping up, notably the installation of cavity barriers or lack of installation of cavity barriers. Shortly after those claims started to flood into the court, we then had the Act, which was passed obviously following its bill stages. Most of that Act came into force on the 28th of June 2022. And then in what amounts to nearly 3 years since, we've seen a number of first instance decisions where aspects of those kind of claims have been teased out, and a number of matters and defences which might have been run have been comprehensively thrown out. We've had 2 cases that went to the Court of Appeal and were heard this week. We've had a case that went to the Supreme Court in December 2024, where we are awaiting judgment. So really, it's been a very, very busy time.
Absolutely. And it's important to remind ourselves of the context, precisely because understanding the purpose behind the Building Safety Act has often given rise to a particular approach by the judiciary in interpreting its provisions. And the fundamental purpose, if there's one single purpose behind the Act, it was to protect leaseholders. That was the real political force that came behind delivering the legislation. The Act itself is an Act of 6 parts. to secure the safety of people in and about buildings and to improve the standard of buildings. It introduces new remedies, the remediation contribution orders, remediation orders, building liability orders. There are new causes of action against building product manufacturers, suppliers, and the like. But it also, of course, introduces these new limitation periods, which we will come on to consider. Before addressing the question of limitation, we have to remind ourselves of the provisions of the Defective Premises Act, 1972, upon which the extension to limitation periods under the Building Safety Act are effectively parasitic. The statutory duty under Section 1.1 of the DPA 1972 states that a person taking on work for or in connection with the provision of a dwelling owes a duty to every person who acquires such an interest in that dwelling to see that the work which he takes on is done in a workmanlike or, as the case may be, professional manner. And the aim of that is that, as regards that work, the dwelling should be fit for habitation when completed. Now, just pausing here, one important change to the judicial perspective, one might say, that we see in BDW Trading and Ardmore in the High Court is the declaration that disputes under the Defective Premises Act can be subject to adjudication proceedings. So the essentially statutory regime is now subject to what is normally a contractual regime for adjudication. And in addition to that, because we see extension to the limitation periods under the DPA 1972 by virtue of the 2022 Act, those limitation periods, extended limitation periods, will now be available to parties who want to argue them before adjudicators. So it's quite an important change to the law, isn't it, Sian?
Yes, certainly. And exactly how that will continue is uncertain. I mean, the idea that you would have a Defective Premises Act cause of action being determined by an adjudicator is extremely novel when one looks at adjudication as being confined to the statutory scheme or to the contracts between the parties. And such contracts don't usually include reference to the Defective Premises Act. So we'll have to see where that develops.
And it's another example, isn't it, of the myriad of ways in which the statute and the various questions that it is raising for practitioners will continue to change the landscape for years to come. One of the important ways that we've touched upon already today, but we haven't gone into detail on, is in relation to the extension to limitation periods. The extension to limitation periods was a novel aspect of the new statutory changes and new regime that was long anticipated. And is, of course, incredibly important because it extends limitation for works completed back to 1992 up to the 28th of June 2022. So an extension of limitation of 30 years for buildings completed on or after the date of commencement of the Act, namely the 28th of June 2022. That limitation is extended to 15 years. It's also worth bearing in mind that Section 2A, introduced by way of the Building Safety Act, means that the Defective Premises Act duties don't just apply in respect of new dwellings, but are also applying in respect of refurbished dwellings, albeit not retrospectively applied. So having dealt with the question of limitation, there's one anomaly that it's worth dealing with, which is Section 38 of the Building Act 1984. Now, why are we going back to 1984, you might wonder? Well, Section 38 was introduced by way of the statute in 1984, and it, in principle, applies civil liability for breach of a duty imposed by building regulations so far as it causes damage. It gives private individuals the right to claim damages for damage, including personal injury, suffered because a building does not meet building regulations standards. And under the Building Safety Act, we know that there was an extension of the limitation period for this action up to 15 years by virtue of the new Section 4B of the Limitation Act. But the strange thing is that it's not in force. And we will have to watch this space. There was a lot of anticipation, wasn't there, Sian, that it would be brought into force by way of this statute, but that seems not to have happened.
Yes, quite. The idea that you would extend the limitation period from 6 years to 15 years in the BSA 2022 and yet not enact the act that existed from 1984 seemed utterly bizarre. And it's been a case of anticipating it will come into force and constantly scouring the updaters to see if that's what's happened. But it appears it's not coming anytime soon. That said, watch this space. We'll have to see what happens. But of course, that would be a game changer. One would have the very route that you need for these individuals to be able to pursue these claims.
And having touched upon some of the existing causes of action, even those that perhaps haven't seen the light of day properly yet, we want to move on next to one of the important new causes of action, or at least new orders that might be provided under the Act, and that's the building liability orders. And for this, I'm going to turn to Sian.
Thank you, Paul. Yes, the building liability orders part of the Act is sections 130 to 132, and it provides a wholly new cause of action and remedy whereby the developers who have been in the habit of using special purpose vehicles, SPVs, to carry out their developments, were able to absolve themselves of responsibility for such matters as we are now seeing by way of all these claims in the Technology and Construction Court. This was one of the main reasons why there was going to be some major statutory change, and certainly it was heralded as a way of ensuring the developers were on the hook for these kind of defects and the costs of remediating. What we have in section 130 subsection 2, which defines the building liability order, is the description that it is an order providing that any relevant liability of a body corporate, which is the original body, relating to a specified building is also a liability of a specified body corporate or a joint and several liability of two or more specified bodies corporate. So in effect, what you have is a removal of what might also be called the corporate veil. One body corporate can be held liable for the liabilities of another body corporate. It applies to, via the operation of these sections, to any claim brought under the Defective Premises Act, as Paul has just discussed, or Section 38 of the Building Act, which is not yet in force, or arising from a building safety risk. And it effectively extends the liability from that original body to its associates. The requirements for this remedy can be summarised as a series of conditions that have to be met, plus a discretion. So the High Court will have to consider whether it's just and equitable to make the order. And although this remedy was heralded as intended to prevent developers absolving themselves from responsibility by use of SPVs, nothing in the Act has actually limited the remedy to those factual circumstances. So it can apply equally between any companies, which means developers, the original intended target, are actually able to use it themselves against contractors, which is not something that we had anticipated would be coming out of this remedy when we saw it in bill form. So the hot topic then becomes, what is an associate? What's enough to be able to get this remedy against an associated company? Turning now to look at the conditions that are required. Firstly, there has to be a relevant liability. And that liability is one that is incurred, as I've said, either under the Defective Premises Act or Section 38 of the Building Act, or as a result of a building safety risk. Now, although we are all looking at this in the context of fire safety matters, building safety risk is not so narrowly defined under this Act. The definition under the Act is that building safety risk means a risk to the safety of people in or about a building arising from any of the following occurring as regards the building: A, the spread of fire, B, structural failure, and C, any other prescribed matter. So one can see that the door is left open for this part of this act to be used in a number of other areas, particularly relating to structural risks. The meaning of liability, relevant liability is the term used in the sections of the Act, and liability is not further defined. So one would be looking for there to be an established body of case law that works out quite what is that requirement. Certainly would imagine that court judgment would be enough, an arbitration award would be enough, and potentially a liability under a settlement would be enough. But speculating now, it's possible that an adjudication decision might not be enough unless it has actually been performed. So if, for example, an adjudicator makes the decision that Company B must make a payment to Company A, that decision in itself might not amount to enough to be classified as a relevant liability. But if Company B actually paid the sum due so that it had performed the required remedy that the liability arising out of the decision required them to do, then it might amount to a relevant liability for the purpose of this Act. And as I've said, it's simply not going to be the case that we know yet quite how broadly this part of the Act can be applied, given it isn't confined to fire safety matters. Turning to the other conditions that are required, that liability of the original body would have to relate to a specified building, because that is clearly what is the requirement out of this section, and that there will have to have been an association with this original body in the relevant period. So the liability of the original company has to be indicated to relate to a specified building. One can't pursue a BLO against developers just because they have created, in the course of whatever period of time, a number of buildings that could give rise to these relevant liabilities. You would have to necessarily be targeting specified buildings. As to the relevant period, well, that is an extremely long period of time, because it means any time between the start of the works, out of which this relevant liability has arisen, until the making of the building liability order. So very long time. That's unlikely to be much of a limit or much of a condition that's not met. And then the body corporate that is referred to in the BLO and is therefore specified has to have been associated with the original body in that relevant period. So those are those further two conditions that have to be met. And the meaning of associate, under the section 131, you can see from the way in which it's set out, turns on the control of one body corporate by another. So for the purposes of section 130, a body corporate A is associated with another body corporate B if one of them controls the other, or a third body corporate controls both of them. The remainder of section 131, subsections 2 to 4, is then concerned with setting out cases which indicate that that body would be considered to be controlling of the other body. So, for example, a body corporate X controls a company Y if X is in possession of or entitled to acquire at least half of the issued share capital of Y, or has such rights as would entitle X to exercise at least half of the votes exercisable in general meetings of Y, and so on. We're looking at the control via the corporate structure and the shareholdings. Once you've met the requirements, those conditions, you then also have to get over the hurdle of the discretion. The wording of the Act is that the High Court may make a building liability order if it considers it just and equitable to do so. So that's the wording of the statute that would trigger the discretion having to be exercised by the High Court. But there is no guidance in the actual Act as to how it should operate. One can look at guidance from other acts, for example, the Civil Liability Contribution Act 1978, Section 2, subsection 1, indicates that for the assessment of contribution, the court can assess the amount of contribution recoverable such that it is to be just and equitable, having regard to the extent of that person's responsibility for the damage in question. And we're all very familiar with that way of applying this discretion. So responsibility isn't just responsibility in the causation sense, it's also an element of blameworthiness, but it derives from this wording within the Act. We have similar instances where the same just and equitable wording arises in other acts. The Financial Services and Markets Act 2000, Section 28, subsection 3, allows the court a discretion to permit enforcement of agreements which are rendered unenforceable by Sections 26 or 27. Or will allow monies or property transferred under such an agreement to be retained. And there the wording is, if the court is satisfied that it is just and equitable in the circumstances of the case. So in that instance of using this wording, the court has to satisfy itself by looking at all the facts and circumstances of that particular aspect that they are seeing in the case before them. There's another example in the Insolvency Act, 1986, Part 4. Section 122, subsection 1, subsection G, provides that a company may be wound up by the court if the court is of the opinion that it is just and equitable that the company should be wound up. There is an example of this particular statutory provision in action in the case of Reclimvest plc, which is a 2022 decision from the Chancery Division, where a winding up order was made where the new activities proposed were so far outside the original company objects that it was not just and equitable to require the members to continue to invest in that company. So we have that kind of statutory guidance, but we are now developing the case law that applies to this discretion within the Act, albeit not necessarily in relation to BLOs, because the just and equitable wording, as you know, arises in other sections of the Act. So to look at BLOs in general and to sum up in terms of who's affected and what impact they'll have, pretty much any company that has a group company arrangement is potentially going to be affected by this, because the group company arrangement is not set up so as to protect it from the effects of this statute. There's potential for association between all of the companies in a group structure where the company that is the family at the head of the family tree, at the head of the group, owns more than 50% shareholdings of the companies that are below it, or has voting rights up to 50%. What impact will it have generally? Well, it means that parties will be bringing in more defendants to these actions. They'll largely not be so much the usual target defendants and will perhaps be called the BLO defendants. That will expand litigation and the scale of each case, but it will increase, one hopes, the prospects of recovery. If it does increase the number of defendants, then clearly that will carry with it a cost risk, which is something which perhaps we have to wait and see how it plays out. But in a scenario where, for example, one launches proceedings and adds a number of names to the proceedings as defendants because they are subjects and targets for BLOs, then they will presumably be able to attend the first CMC. And if they do attend that first CMC, who's going to be responsible for the costs risk of them attending, and how do they participate in these actions? These are all matters which I think we're going to be feeling our way towards, and certainly there are some case management decisions and indications which we'll be discussing in due course. But in terms of the overall effect, corporate veil, as we used to know it, in terms of these kind of companies and these protective minimizing liability structures, that's in tatters. It's no longer, it's been completely sidestepped. Liability is no longer limited to the assets of the original defendant, the original body. One is no longer forced to try and pursue a difficult claim against another company that might have assets by attempting to use such factual circumstances as a personal liability due to particular acts by a director of a company. And it's generally proving to be quite an effective blunt instrument, because the companies that have this group structure are responding to even the mere threat of a BLO that could mean that other aspects of their group structure will be subject to interrogation by the courts. That said, the more recent decisions are not indicating that it's going to be a free-for-all, and the courts are going to take very strict control over the extent of pursuit of, for example, information orders under Section 132. That is going to be permitted, but we'll come and discuss that at a later stage.